The courtroom was packed that Tuesday morning. I felt Barbara Jenkins' smug satisfaction radiating across the aisle. She sat there, whispering to her lawyer, thinking she'd won. Judge Henderson asked if I had legal representation. I stood slowly. Robert Sterling, retired attorney, 35 years with Sterling and Partners. Specialized in property law and civil litigation. The smirk vanished from Barbara's lawyer's face. I had bought Oak Creek Ranch for its isolation, 100 acres, no HOA. Barbara, Maple Grove Communities HOA president, decided she needed an easement through my property for a community trail. She drove to my gate. "We need to establish an easement through your property." I told her, "This is private property. It's not part of your HOA." The answer is no. Over 6 months, Barbara's campaign escalated. She organized community walks, sent letters, and filed false county complaints. The turning point came when I found my padlock cut and trail markers hammered into trees. My new security cameras recorded Barbara herself at 2 a.m., bolt cutters in hand, driving onto my property to install more markers. I installed a steel gate and had my attorney send a cease and desist. Barbara responded by suing me for malicious obstruction of community resources and $50,000 in damages. I dusted off my bar license and filed my answer, asserting counterclaims for trespass, harassment, and defamation. In the preliminary hearing, her young lawyer, Jason Miller, painted me as an antisocial recluse. My turn came. I kept it simple. I presented my deed, the survey, and affidavits. At no time has any easement existed on this property. At no time has it been part of any HOA. Then, I pulled out my manila folder. I have security footage of Ms. Jenkins personally trespassing on my property on no fewer than 6 occasions, including cutting locks. Judge Henderson reviewed the images. Barbara sputtered, "That's taken out of context." The community needed those trails. The judge asked if she admitted to trespassing. Miller jumped up, arguing good faith belief. I submitted Defense Exhibit C, a recorded phone conversation between Ms. Jenkins and another board member where she explicitly states, and I quote, "I don't care if he owns it. We will make his life hell until he gives in." The courtroom went silent. Miller tried to regroup, but the damage was done. Judge Henderson asked if he had any actual evidence of an easement. He shuffled papers. "We're still investigating." The judge said flatly, "So that's a no." Judge Henderson granted summary judgment in my favor on all counts. Barbara's claims were dismissed with prejudice. The judge granted my entire countersuit. Barbara was ordered to pay $15,000 in damages for trespass. She was hit with a permanent restraining order requiring her to stay 500 feet from my property. The judge continued, "Ms. Jenkins, your behavior in this matter has been appalling. I'm also forwarding this case to the district attorney's office for potential criminal trespass charges." Barbara wailed, "But I was trying to help the community." The judge's response was ice cold. "No, Ms. Jenkins. You were trying to bully someone into giving you what you wanted. There's a difference." Barbara was immediately surrounded by angry HOA board members. 3 days later, she was removed from her position by unanimous vote and banned for life. The criminal charges proceeded, and she pleaded guilty to misdemeanor trespass, receiving 12 months probation and 500 hours of community service. I donated the $20,000 in damages and fees to a legal aid society, which named their new conference room the Jenkins Warning Room. Barbara's legacy was not the trail system she envisioned, but a cautionary tale taught to law students.